Hi,
So,
good morning, ma'am. Good morning, Lakshita.
good morning. Let's begin with the session for the day. I would like to welcome everybody to the session.
As counsel can be heard, an application which
I would like to welcome my respected seniors and peers to this very informative session on buyback today. The speakers for today's session are two people who have hands-on experience with buyback. I would like to welcome Ms. Madhuri Pandey, who is a partner at Mamta Banani and Associates, who has hands-on experience in corporate secretarial matters. In addition to the compliances under the Companies Act, she has in-depth knowledge of SEBI-related compliances, FEMA, and NCLT matters. She's an expert in corporate restructuring and is currently heading the corporate law division. Next, I would like to welcome Ms. Ankita Pandey, who is also a partner at Mamta Banani and Associates. Her core areas of expertise and recent assignments handled includes corporate law consultancy, securities law practices, corporate restructuring, MSME matters, trademark registration, NCLT matters, NBFC compliances, due diligence, and contracts, etc. Without any delay, let's dive into the session for the day.
Thank you, Lakshita. I would like to start with the session. I will be explaining as you all know, that today's session is all about buyback of shares by private companies, by unlisted public companies and listed companies. So I will be just giving a gist about the buyback done by a private company and an unlisted public company. So without further delay, let's start. Just give me a minute for sharing the screen. Is my screen visible to everyone? Please confirm.
Yes, Ankita. Please continue.
Yes,
Thank you, Madhuri. So let's start with the relevant sections which cover the buyback of shares. The relevant provisions under the Companies Act 2013 are under Section 68, 69 and 70 of the Companies Act 2013. A company may buy back its own securities, and Rule 17 of the Company's Share Capital and Debenture Rules 2014 govern the regulations of buyback of securities for unlisted companies as well as for private company. Now, I'm straight away going with the Section 68 of the Companies Act. Just to give a gist of Section 68, the maximum amount that is permissible for buyback is 25% of the paid up share capital and free reserve. The maximum paid up equity share capital for buyback is 25% of its paid up equity share capital. So there are two things. The maximum amount which is permissible for buyback is 25% of the paid up share capital and free reserves, and the maximum paid up equity share capital. First is about the amount. The first section is telling us about the amount, maximum amount that is permissible, and the second part is the maximum paid up equity share capital that is permissible for buyback is 25% of the paid up share capital of a company. Next is for buyback, there is two routes. One is board route, another is shareholders approval route. So a company can go through board approval route for buyback of 10% or less of the total paid up equity share capital and free reserves of the company. So the proviso to Section 68 subsection 2 clause B says that if a company is going ahead with buyback of 10% or less of the total paid up equity capital and free reserves, then there is no need to get the approval of the shareholders for that particular buyback. We can directly take the approval of the board, the consent of the board, and we can go ahead with buyback of shares. Then buyback of for more than 10%, but for 25% or less of the total paid up equity capital and free reserves of the company can be done by shareholders approval route. So in short, if the buyback is more than 10%, but up to 25%, because 25% is the maximum limit. So if up to more than 10%, but up to 25%, we have to take the approval of the shareholders of the company. Next is, what are the sources of buyback? A company can purchase its own shares and other specified securities. We all know that the term, what is the definition of the term, or what is the meaning of the term buyback? Let's discuss this before we go ahead with the sources. So a company buyback is nothing but it's an event when a company purchases its own shares from the shareholders, existing shareholders of the company. So a company can purchase its own shares or other specified securities out of its free reserves or the securities premium account, or the proceeds of the issue of any shares or other specified securities. But the catch is here that the buyback of any kind of shares or securities cannot be made out of the proceeds of the earlier issue of the same kind of shares that has been used by the company for that particular buyback. Now, what are the modes of buyback? A company can buy back its shares or other specified securities by any of the following methods. First is from the existing shareholders on a proportionate basis from through the tender offer. So the process, as we all know, we have gone through the sections before also. So in buyback, what is done that we make an offer to the existing shareholders through a letter of offer, and we request them to for buying their shares by making a fair
अच्छा समझ में आया हम क्या बोल रहे हैं मिनिमम बैलेंस रखना होगा ऐसा स्टार्ट से नहीं होता चीजों को वो काटना स्टार्ट कर देगा
Mr. Gupta, can you mute yourself,
इसलिए हम
please?
बोल रहे हैं
Mr. Chandan, can you mute yourself, please?
कौन आया था यहाँ पे
Lady Priyanka बोल रही
प्रियंका ही थे
Lakshita, you can mute him, na?
second.
Yes. So let's move ahead. I was saying that in buyback, what we do, the company generally make a offer to the existing shareholders through a letter of offer, so that they can so that the company can bought back the shares from the existing shareholders. So the first mode of buyback is to purchase the shares of the existing shareholders by making an offer to them. Then from the open market. Third is by purchasing the securities issued to the employees of the company pursuant to a scheme of stock option or sweat equity. Now, there are few conditions that is provided in the act and the rules that has been prescribed for the buyback of shares. The first is that there should be an authority in the articles of the company for making the buyback offer. So the buyback is authorized by its article. If not have the power in articles, then we have to first alter the AOA of the company for going ahead with the buyback of shares. Next is the debt equity ratio should be, so after making the buyback, the post buyback debt equity ratio cannot exceed 2:1. Then the buyback completion timeline. Every buyback is required to be completed within 12 months from the date of passing the special resolution or the board resolution, as the case may be. So the case could be more than 10%. If more than 10%, then we have to go ahead with the special resolution. If it is up to 10%, then board resolution is enough, and we can do so within 12 months from the date of passing such a resolution. Next is creation of a capital redemption reserve account, where a company bought buyback, where a company bought back shares out of free reserves or out of the securities premium account. Then an amount equal to the nominal value of the shares need to be transferred to the capital redemption reserve account. So the company has to create a capital redemption reserve account, which is going ahead with the buyback of shares. And in that particular account, an amount equal to the nominal value of the shares needs to be transferred in that particular CRR account. Such transfer details to be disclosed in the balance sheet. We have to give the disclosure in the balance sheets. The capital reserve account may be utilized for paying unissued shares of the company to the members as fully paid bonus issue. Next is there are restriction on buyback. The companies are restricted to buy back its shares through any subsidiary company, including its own subsidiary company, or through any investment company or group of investment companies, or if a default is made by the company in the repayment of deposit. So this is the particular restriction which has been imposed by the Act for buyback of shares. Next is the restriction on withdrawal of buyback. The company shall not withdraw the offer once it has announced the buyback to the shareholders. So once you have announced, you have dispatched the letter of offer to the shareholders for buying their shares, you cannot withdraw, a company cannot withdraw the offer once it has announced the same. Next is no buyback or no offer of buyback under subsection 68(2) of the Companies Act 2013 can be made within a period of 1 year reckoned from the date of closure of the preceding offer of buyback. So we can say that this is one of the restriction, not prohibition, it is a restriction that the company shall not make no offer of buyback shall be made within a period of 1 year reckoned from the date of closure of the previous offer that has been made for buying back of shares. A company buying its share, a company buying back its securities is prohibited for making a further issue of shares within a period of 6 months. So a company cannot go ahead with further issue of shares within a period of 6 months from the date from which the company has made a offer of buyback. So these are the forms which are required to be filed with the ROC for buyback of shares. As we know that if an unlisted public company is going ahead with buyback of shares, it is required to file MGT 14 for the resolution which has been passed for buyback of shares. Although private companies are exempted by the notification which has been issued on 5th June 2015 from complying this particular requirement of filing MGT 14 under the provisions of section 179(3). But we always suggest that it is a good practice if a private company is also going ahead and filing MGT 14 for the resolution, for the board resolution it is passing for authorizing the buyback of shares. It is a good compliance, we believe. Then SH8 is nothing. It is a letter of offer. It is the tender offer that we are making to the shareholders of the company for buying their shares. Then SH9 is the declaration of solvency, which is required to be filed by the company with the ROC. SH11 is a form which is required to be filed after we do the verification and the completion of offer is made by the company. Then the next step is extinguishes. If now if we are buying the shares of the company, the share certificates that we have issued to the particular shareholder needs to be destroyed, because if the shares we have the company, as a company we have bought back the shares of that particular company, there is no meaning of the share certificates which has been issued to the shareholders. So we have to destroy the share certificates, or rather we can say that we have to extinguish the rights which are attached to the shares which has been issued to that particular shareholder. So this is a form which is required to be filed with the ROC for buying back the shares of the company. Next, I have just put a timeline to understand the activities, the schedule, just in a gist that what a company required to do, what is the requirements that a company needs to do with buyback of shares. So the first thing is to conduct the board meeting for approving the buyback and also decide the date and issue the notice of extraordinary general meeting for approval from the members. But this is only required if the buyback, as we have discussed, that it will be only required if the proposed buyback is more than 10%. So I have just highlighted that the number of days or time that is required, or if we just consider that if we conduct the board meeting on X day, then according to that day, this is the timeline which I have created. Next is notice of EGM to be sent to members. If the proposed buyback, again, if the proposed buyback is more than 10%, then the notice of EGM needs to be sent to the members. Then to conduct the EGM of members for approval of buyback, if the proposed buyback is more than 10%. Next, we need to file MGT 14 along with the extract of the SR. The explanatory statements need to be attached. The timeline is within 30 days from the date of passing such SR, we need to file MGT 14. Next, filing of letter of offer in SH8 and declaration of solvency in SH9 with ROC along with the affidavit. So there is in SH9, we have to give an affidavit. The directors of the company have to give an affidavit that this particular buyback will not affect the solvency status of that company. The company will be in a good position to carry on its business activities. Next is dispatch of letter of offer to the shareholders immediately after filing the same with the ROC, but not later than 21 days from its filing with the registrar of companies. Offer period shall remain open for a period of for not less than a period of 15 days and not exceeding 30 days. So it means the offer period shall remain open for a period of 15 days. We have to open the period for a period of 15 days and not exceeding 30 days from the date of dispatch of letter of offer to the shareholders. Next, now the period of 15 days can be reduced to any such particular day which may be decided by the members of the company if all the members of the company agree to it. Then the company shall complete the verification of the offers received within 15 days from the date of closure of offer. Next, opening a separate bank account immediately after the date of closure of the offer. This is one of the most important points which we have as a professionals have to guide our clients, that a company which is going for a buyback, it has to open a separate bank account immediately after closure of the offer, where it can park the amount that we have to give to the shareholder from which we are buying the shares. The company shall within 7 days of the time specified in sub-rule 7 of Rule 17 make payment of consideration in cash to those shareholders or security holders whose securities have been accepted, or return the share certificates to the shareholders whose securities have not been accepted at all, or the balance of the securities in case of part acceptance. So the timeline is within 7 days, we have to do all the payments and all the necessary compliances related to share certificates. Next is maintenance of register of shares bought back in SH10. So SH10 is a form. It is a register in which we have to maintain the particulars of shares that has been bought back. Next is within 7 days of the last date of the completion of the buyback, the shares bought back needs to be extinguished. Last, we have to file form SH11 along with the declaration within 30 days of the completion of the buyback. Okay, now as we have discussed that in case of a private company, the shares will be in a physical form, the physical share certificates will be there. So it will be easy for a company to just, strike off or just do the proceedings related to extinguishment of shares. But what if in case the shares are in demat form? Then if the shares of a company, like in case of an unlisted public company, the shares will be in form of demat form only. So in that particular case, the role of RTA comes. So what is the role of RTA in the buyback of shares? Post receipt of the buyback consideration by the intended shareholder, the company shall apprise the same to its RTA, who shall then proceed with a corporate action with respect to the extinguishment of shares. For this, the company shall provide all the approved forms along with the supporting attachments to the RTA, who shall, upon receipt of the same, shall verify and update NSDL or CDSL accordingly. So I think I have covered all the aspects of a private company and an unlisted public company. Just one thing that I would like to highlight, that if we all have read section 17, rule 17, that is related to the buyback of shares, and we have seen a particular point where it is written that the price needs to be determined on the price on which we are buying back the shares needs to be determined. So how can a person can determine, or what is the basis of that determination? As per in the rule or in the section, it is nowhere written that the valuation of the share valuation from a registered valuer is needs to be done. But as we have handled the cases, and as a professional, I believe that it is always better that we get a valuation certificate from or valuation report from a registered valuer while going ahead with the buyback process, and while determining the price for on which the company is buying back the shares from a particular shareholder. So that's it. Now I would request Madhuri to go ahead with the listing provisions related to buyback. Thank you.
Thank you, Ankita. Thank you for explaining the provisions of buyback applicable on private and public companies so nicely. So now I will be taking forward the nuances of buyback applicable on a listed company. So I'm just sharing my screen. Is it visible?
Yes, Madhuri.
Okay, Ankita, thank you. So, as we understood from Ankita, that for private and public companies, Section 68, 69, and 70 are applicable. However, in case of listed companies, in addition to Section 68, 69, and 70, which are there in the provisions of Companies Act, we need to comply with the SEBI Buyback of Securities Regulation 2018 as well. So for listed companies, for doing the buyback, basically there are two options available with the listed companies. One is tender offer and another is through open market. We all know that a recent notification has come in the March in March 2023, wherein we have observed that earlier what was happening, that many of the companies are doing the buyback through open market, through stock exchange, but now that option is also has been done away with. So if we consider that and if we ponder upon the notification, then we would see that after 1st April 2025, the option of doing the buyback through stock exchange is no more available to the companies. So now the only option that is left with the company is for listed company is doing the buyback by way of tender offer. Obviously, the process of book building process is also available, but in India, we have observed, and I have also studied the money control and seen online that till date, none of the companies have opted the process of book building for doing the buyback. 2-3 companies has tried for it, but they also failed. So whatever successful buyback which we have seen for the listed companies, it has been done by way of tender offer only. And the process of tender offer is to some extent is similar to the provisions which is there in the Companies Act. So basically today we will be studying and we will be understanding the provisions of tender offer and how the process of tender offer is required to be completed for doing the buyback of listed companies. Just a second. Slide change हो रहा है क्या?
No.
अच्छा. So basically, this is the process of. Now, is it visible?
Yes, Madhuri, it is visible.
Yes. So for doing the buyback through the process of tender offer, basically this is the process. If we will see the buyback regulations, which is applicable on listed companies, basically it is divided in 5 chapters. So chapter 1 is like Companies Act, only the definition part and the basic stuff. Then chapter 2 comes, which talks about the general obligations and conditions, basically the conditions which are there for doing the buyback. Then chapter 3 deals with the process of tender offer. Chapter 4 deals with the process of buyback through book building process, which we just discussed that in India, none of the companies have opted for book building. Means 2, 3 have opted, but they also failed. So there is no successful company who have done the buyback through book building process. And chapter 5 is basically the general obligations which are there for listed companies for doing the buyback. So for the tender offer thing, the process is generally, firstly, we need to pass a special resolution or board resolution, as the case may be. Then within 2 working, and obviously in case of listed companies, for passing the special resolution, basically the companies goes for the process of postal ballot. So postal ballot itself is a very lengthy process, and I am assuming that you all are you all have the basic knowledge of postal ballot, so we are not touching that part. So after passing the resolution through postal ballot, within 2 working days, the companies are required to make a public announcement. So as the name itself is suggesting, public announcement means making the stakeholders know, making the stakeholders aware about the corporate action which the company is going to do. So for doing the public announcement, what will the company will do? Company will inform all the shareholders by way of email. Obviously, they will be having a RTA, means for doing the buyback, for the whole buyback process, company will have to engage a RTA for the buyback thing only. So that RTA will send the news of this public announcement, news of buyback, all the particulars of buyback to all the shareholders who are entitled for the entitlement of shares. And then public announcement also refers that for public announcement, we also understand that we will have to make a newspaper advertisement. Then this public announcement on the same day needs to be informed to the stock exchange, like we do for all other compliances. Any day when we do any kind of public announcement for publication of financial result, or for any corporate action for which public announcement is mandatory, on the same day itself, it is required to be intimated to the stock exchange as well. Stock exchange means wherever the company is listed. If the company is listed on BSE only, then only we need to intimate to the BSE. And if the company is listed on BSE as well as NSE, then we are required to intimate BSE as well as NSE. Then the letter of offer needs to be filed. Like Ankita explained to us that in SH8, letter of offer needs to be intimated to the shareholders who are entitled for the shares in buyback. And also for any company who is going for buyback needs to file a declaration of solvency. Means this cannot be the case that if the company has failed in repaying its statutory payments, or default in making payment of interest or any kind of deposit, or any payment to state authorities. Means basically the understanding is that the defaulting companies cannot go for buyback. So you means the company needs to be a solvent company for doing the buyback. Hence, along with the letter of offer, declaration of solvency means the company is a solvent company. A declaration by the directors, by the management, needs to be filed with the SEBI as well as through the stock exchange. And this the whole process would be taken care by a merchant banker. Then this letter of offer along with the tender form needs to be dispatched to all the shareholders. To the shareholders, obviously we all know that the share means the shares of a listed company is changed on day-to-day basis. So means today if my company will have 65,000 shares, then it may so happen that tomorrow my company will have 64,000. So number will change, and also it is basis the trading only. So the concerned companies are required to fix a record date, and on that record date only, we will determine that who are the shareholders who are entitled for this buyback offer, and we will dispatch the letter of offer to them only. Then offer period will start, and obviously in the maximum and minimum period of offer is different in case of book building process. It was different in case of buyback through stock exchange, and it is different in case of tender offer only. So in tender offer, as per the recent buyback, the maximum date is 7 days. So after the means in the meanwhile, when the offer period is opened, the companies are required to open an escrow account, and in the escrow account there is a provision that if the total buyback amount is not exceeding 100 crore rupees, then 25% of the consideration needs to be deposited in the escrow account. And if the consideration payable exceeds rupees 100 crore, then 25% up to rupees 100 crores and 10% thereafter needs to be deposited in the escrow account. And once this buyback process is completed, then the companies are required to extinguish all the shares. And this extinguishment obviously will means this extinguishment needs to be vetted by the secretarial auditor of the company as well. So for being a professional, for us, for company secretaries, there is a huge scope that even if a merchant banker is there, or even if a RTA is there, apart from the compliance officer who are there for the concerned companies who are doing buyback, even the professionals who are in practice, they also play a huge role. They need to see that the process of buyback is done in accordance with the buyback regulations. They need to serve a certificate certifying the same. They also need to see that whether the extinguishment is being done through following the due process. Then after receiving the letter of offer, like we have studied in case of private and public companies, the offer letter needs to be verified, the amount needs to be paid, and after the process is completed, the shares needs to be extinguished. In case of demat, in case of shares who are in demat form, the extinguishment will be done by the RTA, and in case of physical shares, it will be done by RTA, as well as company also plays a huge role. So after paying the consideration, this process would be completed. But in the whole process, what we generally see that being a shareholder, what we generally see that for general shareholders, they do not have the idea that if I want to avail the buyback offer, what should I do? But generally what happens is that the company, as we discussed, that the company sends email, means the RTA as well as the company sends email to all the shareholders, giving them the offer of buyback. But generally it goes into our updates folder or trash or spam, and we do not, means the normal shareholders, they do not pay attention to the same. So today what I want to show you is we all have read and seen that recently TCS has undergone the buyback, and we all know that TCS is a listed company. So I will be showing you the tender offer letter of TCS along with the email, which, since I am a shareholder of TCS, so what is the email, how it looks like, and what details they have provided to me, so that I can avail the buyback offer. So I will be just sharing that with you for your knowledge. So this is the email which TCS has sent me. Is it visible to you all?
Yes, Madhuri.
Yes. So this email has been sent to me by link in time. Okay. And link is the RTA to this issue. Like we understood, we discussed that for doing the buyback in case of listed company, the companies are required to appoint a RTA for the particular corporate action. For example, if I am doing a bonus issue, I need to appoint an RTA, despite the fact that in case Maheshwari is my RTA, but for doing the bonus issue, I can also appoint niche securities. I can also appoint fintech. I can also appoint MCS. Means I can appoint anyone for that particular corporate action. So in the case of buyback of TCS, the RTA was link in time. So what link in time has sent me he has sent me that for doing the TCS buyback 2023, they have also done it through tender offer route, and they have mentioned that as on record date, since I am holding only 10 shares, so for 10 means their ratio is 10:1. For 10 shares, I will be getting only one entitlement. So if I would have wanted to apply for this buyback, then only my one shares would have been bought back by the company. So what other documents they have sent me? They have sent me letter of offer. They have sent me tender offer. In case of demat shares, they have sent me tender offer for physical shares. They have sent me share transfer deed, that is SH4. So if my shares would have been in physical form, then I would have applied to them by filling up the tender form for physical shares. But since my shares are in demat form, so if I would have wanted to apply for this buyback, so I need to fill this tender form, which is there in case of demat shares. They have also sent me the full letter of offer indicating the particulars, etc. So in the letter part, what they have mentioned that for availing this buyback, I need to follow the due process. I need to click on this link, and after clicking on this link, one tab will open wherein it will indicate, since the date has gone, so I cannot show you that. So after clicking on this link, one tab will open, that is TCS buyback 2023. I need to select whether my shares are in demat or in physical form, or I can directly mention my PAN also. Even if I will only fill my PAN, it will automatically redirect me to the window wherein it will show that my shares are in demat or in physical form. Then I am only required to fill my DPID or folio number or PAN. And then the form of acceptance cum acknowledgement would indicate. In this, on this page, I need to upload the duly filled tender form in case of demat shares. Also, the particulars of buyback is also written over here, which is which is obviously the opening date. Opening date was December 1. The buyback closing date was December 7. And the last date for receipt of required documents was December 7 only. Like we discussed that I had to fill that tender offer in case of demat share. So I needed to upload that form. Also, they have mentioned the face value of shares is 1. The maximum amount of buyback which was there is 4 crore and 9 lakhs and 63,855 rupees. So they have gone for the buyback of 4 crore rupees approx. For buyback offer price per equity share was 4150. Obviously, why will a shareholder will go for buyback? If we all know what face value means, and we all know what market value of shares means. So for example, if the market value of shares of TCS is, for example, if it is 3,000 rupees, then obviously if the company will offer the buyback for 3,000 or even for 2,500 or for 2,900 or for 3,500, why will a shareholder will avail that offer? Obviously, if I will get anything extra, then only I will avail for that offer. So for this buyback, they had fixed the buyback offer of rupees 4150, 4,150. So they have also given the FAQs. We can read the FAQs also. And if there is any difficulty in availing the buyback offer or in filling the form or any link issue or OTP, many things happens. So in those cases, they have provided a contact number and email ID as well. So we can contact TCS or we can contact the concerned person by just calling this number or by sending an email on this number. So I also wanted to show you the tender offer letter and also the tender form along with the letter of offer, so that we also get an idea that how means being a professional, how is it drafted, and what are the points which we should consider while doing the buyback of listed companies. Is it visible? The tender offer. So basically this is, sorry. So basically this is the tender form which TCS has sent to me. In this tender form, which are there for demat shares, basically the basic information was there, that what was the buyback opening offer date, buyback closing date, and also the maximum amount of buyback per share amount, the maximum number of shares. Then also means what I had to fill in was the number of equity shares as on record date. It may so happen that they have mentioned that as on record date, my number of shares was only one. As per my records, it could be different, but means that probability is very less, but it may happen. It may happen. So what I need to write is, as on record date, what is the number of shares which I am holding. Same in words, the number of shares for which I am entitled for, my DPID number and my client ID number, and the name of my broker. So I need to just fill in these basic details which I am having, and I need to upload this tender offer in the link which I had shown you just before some time. So this is very basic, and also means during this offer period, I need to just fill in this tender offer letter and send it to the company, upload it in the company's link. I can also send it via email. And once this offer period closes, then automatically that particular share would be bought back, would be extinguished, would be cancelled from my DPID, and in my bank account, that amount of buyback would be automatically get credited. And so this is the letter of offer which they had sent me. So in this letter of offer, basically they have given all the details regarding to the number of shares which they have offered, how they have arrived at basically the buyback price, and also the offer period through which it is open. Then as we mentioned, that registrar to the buyback could be a different RTA as well. So they have also mentioned that link in time is the registrar to the buyback. Their manager to the buyback is GM Financial. So this is the opening date, this is the closing date, this is the last date and time by which I needed to upload or send my tender offer. Then how this ratio has been determined, then what are the then other basic details, then when was the board meeting held, what are the disclaimer clauses, what are schedule of activities, details of buyback, authority for the buyback, what is the objective of the buyback. Obviously, because in listed companies, basically it is driven by the shareholders only. So the management needs to make the shareholders aware that what the company is proposing to do, what are the basic objectives behind that, what is the rationale behind that, and what is the purpose or outcome which the company wants to pursue or obtain or achieve. So that there should be a transparency between the shareholder and the management of the company. Then what is the basis of calculation of offer price, sources of buyback, then also the details of escrow account, the capital structure of the company, brief information of the company, financial information of the company, details of statutory approvals, what are the approvals which company has taken for doing this buyback. Then details of the registrar to the buyback, like we discussed, the process and methodology for the buyback, the procedure for tender offer is also mentioned over here, the whole note on taxation, then the declaration by the board of directors, then auditor certificate. So documents for inspection, if you want to inspect, what the details of compliance officer, details of remedies available to the eligible shareholders, details of investor service center, details of the manager to the buyback, declaration by the directors regarding authenticity of the information. So what we just see is that what we have observed is that like in case of offer letter for public and private company, basically the basic details are same, and in addition to that, whatever is applicable on listed companies, the listed companies are mentioning those details also in their offer letter. So this is there. And so basically this was the basic process of buyback for in case of listed companies. So this was the process of tender offer. Like in the beginning, like I mentioned that the earlier the modes which were available to the companies for doing the buyback was through tender offer, which generally companies follows. Like we have observed that recently L&T, Wipro, TCS, then one more government company has undergone for India Mart has gone for buyback, and all of them have followed the process of tender offer only, which we just discussed. Apart from this, the companies, like you mentioned, the other modes which were available is book building or through stock market, open stock market. Through open stock market, that mode is only available till April 1, 2025. After that, that mode, the option for doing the buyback through that mode has been done away with. So that is not relevant, and we will not be studying that. And also for book building, till date, no companies has means two companies have tried for it, 2-3 companies, and they also failed. So there is no successful company who has done the buyback by way of book building. So we will be just discussing the process in very briefly. So in book building also, the process is same like BOD, board resolution, special resolution, then public announcement needs to be done. Here, what happens is the buyback price is not fixed. Here, companies like what we have in our CS professional, we have studied, like in case of QIBs or ADR, GDR, what happens is that the companies fixes a price band. Here also a similar kind of concept is there, that in case of buyback through book building process, the companies used to fix a price band, and the shareholders uh, needs to do bid on it. So they need to file their bidding. There is a time gap, like in case of tender offer, the offer period is open for 15 days. In case of book building, for example, if it is for 7 days, I need to bid if the price band in between 15 to 30, and I want to avail the buyback offer on rupees 30. Then if I am an entitled shareholder, I need to bid on rupees 30, and after the result is announced in the maximum bidding price only, the buyback will happen. So the process is like that only, and in that process the companies are required to file the public announcement. Then there will be a opening of buyback period. It will be for 15 days, maximum 30 days. Some cutoff price would be fixed, then price would be determined basing the basis the bids received from the shareholders. Then this offer period will close, then extinguishment, etc. will happen. And like we discussed, the buyback through stock exchange mode, now it is not available. So yes, this is it. I also wanted to discuss the taxation angle if you people are interested. Else we can skip, but basic since tax is not our forte, but I would just like to touch this portion. Like basically what I have observed, that companies have two options to reduce its shares if they want to increase their EPS, or they want to keep a hold on their company, or they want to increase the promoter shareholding. Then usually the companies, or they want to just keep a control on their shareholding, so that the ownership would be in the hands of promoters only, or in the hands of owners only, who have created the company, who has the control over the company. So basically, if you will go for capital reduction, then the tax will fall in the hands of the shareholders. And we all know that if we are talking about the promoters, there is a huge probability that they will fall under the highest tax angle, the tax slab. that is 30% or even in some cases 40%. So basically what we have observed that to reduce the taxation thing, the companies used to do buyback compared to capital reduction, so that we all know that in case of domestic companies, in case of Indian companies, the percentage of buyback is 20% only, and the tax is being paid by the companies only. It does not lie in the hands of shareholders. The tax burden does not fall on the shareholders. So that is why we have observed that the company does buyback in case of Indian companies. This is there. So if you people have any queries regarding to buyback for listed companies, or if you people have any queries on buyback on private or public companies, Ankita and me would love to take that. That's it from my side. Thank you.
I request anyone who has any queries to please go ahead and ask.
Good
Both
morning,
our
ma'am.
speakers.
Ma'am, I have a query. Ma'am, the email which you have showed related to TCS, in that email it was written that the date of opening of offer is 1st and closing of offer is 7th. So that means they have the offer period was of 7 days. So have they taken approval from the members for shorter offer period?
No, it's not like that, Sakshi. I mentioned in the very start that there is no minimum maximum period. Like in case of private and public companies, it is 15 days, and if they want to give an offer period for lesser than 15 days, they need to take approval from shareholders. But in listed company, that is not the case. The minimum period is 4 days only. So they can fix a offer period for a time period of 4 days also, and after 4 days they can keep the maximum period as per their will.
Okay, ma'am. Thank you.
That is the case. Welcome. We need to study chapter 3 of buyback regulations. It is mentioned over there that the minimum time period is 4 days only.
Any other query?
Ma'am, I'm having a query. Like in most of the cases, we see that the ROC also requires send us a resubmission query that please provide a valuation report and valuation records on that. But nowhere in the buyback section we get the particular expressively written that valuation report is required. So what can be the reason behind that?
See, Ayushi, in the rules, it is mentioned that the basis of determining the price on which the buyback offer is made needs to be given. We have to write that in the explanatory statement. Now, to determine the price, what could be the practical aspect? We as per the practical aspect, we understand that for doing so, we have to get a certificate from a auditor. But just to justify that from where we are getting that price, it is suggested that we take a certificate from a registered valuer and affix that in the form, just because so that the form will not be, the ROC do not ask for resubmission or the reasons. That is, it is always there. Therefore, it is always advisable that we get a certificate from the valuation done from a registered valuer, just to avoid the complications.
Okay, ma'am. Thank you.
Thank
Hi,
you,
Shivam
Madhuri.
sir.
Hi. Thank you, Madhuri.
Thank you, sir.
Thank you so much. And actually, one information I wish to add, with your permission.
Yes, sure, sir.
Obviously,
So-
sir, you don't need our permission.
After this company's prospectus and allotment of securities, second amendment rules is notified. The private companies, which is not a small company, is also mandatorily required to first make demat. Then only they can buy back the securities.
Yes.
Okay, they have to take into this account before proceeding with buyback, because it will be a problem.
Absolutely right, sir. Because the demat provisions are now applicable on private companies as well. So for any corporate action, we will have to firstly convert the shares into demat form.
Yes.
Right, sir.
Thank you.
We will keep this in mind.
Thank you.
Thank you for your input, sir. Thank
Thank
you.
you.
Thank you,
Thank
everyone.
you. Thank you.
Thank you,
Thank you,
everyone.
ma'am.
Thank you,
to
ma'am.
all. Thanks to all.
Thank you, everyone. Thank
Bye.
you,
Thank you,
both
sir.
our speakers for the day.
Thank you. Thank you, Lakshita. Thank you, Sakshi. Bye.
Bye.